Question number 51. Match the names of the cases in the core issues. A. Geeta Hariharan and another versus Reserve Bank of India, AIR 1999. B. Srimati Sarla Mudgal, President Kalyan and others versus Union of India and others, 1995. C. Hiralal P. Harsora and others versus Kusum Narottam Das Harsora and others, AIR 2016. D. Daniel Latifi and another versus Union of India, AIR 2001. Here the correct match will be for option A, Geeta Hariharan and another versus Reserve Bank of India. Correct match is guardianship. For option 2, Srimati Sarla Mudgal, President Kalyan and others versus Union of India and others, AIR 1995. The correct match is conversion for marriage. Option C, Hiral P. Harsona and others versus Kusum Narottam Das Harsona and others, AIR 2016. For this question, correct answer is domestic violence. And the last, Daniel Latifi and another versus Union of India. Correct match is maintenance. D. Now let us see the question number 52. In divorce proceeding, a decree for judicial separation by way of alternate relief under section 13A of Hindu Marriage Act 1955 cannot be passed where the relief sought is under. Options are section 13 subsection 1 clause A of the Hindu Marriage Act 1955 cruelty. Option second, section 13 subsection 1 clause 2 of Hindu Marriage Act 1955 conversion to another religion. And option 3, section 13 subsection 1 clause IB of the Hindu Marriage Act 1955 desertion. And option 4, section 13 subsection 2 clause 2nd of the Hindu Marriage Act 1955 husband guilty of rape, sodomy or bestiality. Here the correct answer is option number 2nd, that is section 13 subsection 1 clause 2 of Hindu Marriage Act 1955 conversion to another religion. Question number 53. The Hindu Marriage Act 1955 is applicable to first A Jain and B Buddhist, both having domicile in Sikkim and working in United Kingdom. Option 2, C a Sikh, D a Hindu, both having domicile in United Kingdom and working in Sri Lanka. Option 3, G and H, both Hindus, having domicile in Bhutan and working in the United Kingdom. Fourth, all of the above. The Hindu Marriage Act 1955 will be applicable. Jain also comes into the category of Hindu related to Hindu Marriage Act, and Buddhist also. They have a domicile in Sikkim, which is in India only, and they are working in United Kingdom. They have the domicile of Sikkim. It means that Hindu Marriage Act will be applicable to them. Right now they are working in the United Kingdom. But in the other options, the domicile is United Kingdom, and here the domicile is Bhutan, which is not the territorial jurisdiction of India. Therefore, the correct answer will be option 1, A Jain and a B Buddhist, both having domicile in Sikkim and working in United Kingdom. Now let us see the question number 54. Which of the following included within the degrees of prohibited relationship under the Hindu Marriage Act 1955? First option, lineal ascendant of the other. Second, wife or husband of lineal ascendant or descendant of the other. Option 3, children of two sisters. And option 4, all of the above. In the given options, all options are correct. Fourth will be the right answer. Now let us see the question number 55. No tax without authority of law is a principle embodied under the article of the Constitution of India. Options: Article 226, Article 32, Article 245 and Article 265. Correct answer is Article 265, which says that tax is not to be imposed save by authority of law. No tax shall be levied or collected except by the authority of law. Question number 56. Is a writ petition maintainable against an order passed by the Supreme Court on the judicial side? If so, under which article of the Constitution of India? Options are yes under Article 32, yes under Article 226, yes under Article 32 as well as Article 226. No, the writ petition is not maintainable. In this question, correct answer will be option 4. Writ petition will not be maintainable in this case. Now let us see the question number 57. A foreigner applied for a job with a state enterprises. Her application was rejected summarily on the ground of religion and place of birth, despite the fact that advertisement had no such criteria stipulated therein. Which article of the Constitution of India can she take recourse to? Options are Article 15, which prohibits discrimination inter alia on the ground of religion and of place of birth. Article 16, which allows equality of opportunity in matters of public employment. And Article 14, which guarantees the equality before law. Option 4, none of the above. In this question, correct answer is option 3, Article 14, which guarantees the equality before the law. Because here the foreigner has applied for the job, not the Indian citizen. In case of Indian citizen, the guarantees of fundamental rights will be implemented more comprehensively. Question number 58. Parliament in exercise of power under Article 368 makes a law which does away with the fundamental right conferred under Article 15 of the Constitution of India. The executive seeks to defend the challenge instituted in court based on the clause 4 of Article 368, which prohibits such action being questioned in court on any ground. Can the challenge in this court be sustained? Option are no, the challenge if made in a court action cannot be sustained. Challenge is sustainable. The only remedy lies in bringing a fresh amendment. And option 4, none of the above. In the question number 58, Correct answer is second, challenge is sustainable. And Article 368 is related to the amendment of the Constitution. Question number 60. A person who is a businessman continues in preventive detention under a law enacted by the state without the matter being referred to the advisory board, which is the most appropriate provision of the Constitution of India. He should take recourse to option 1. Article 19, subsection 1, clause G, Article 20, Article 22, none of the above. In the question number 60, the correct answer is Article 22. Article 22 says that because of Article 22, it will be the infringement of fundamental rights. So Article 22 will be implemented, and Article 22 states that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Now let us see the question number 61. When a contract is broken, there can an aggrieved party sue only for losses or damages which naturally arose out of breach, and also for the losses or damages which are a result of breach of contract. In view of the statement, which of the following is correct? Options are all the types of losses or damages can be claimed. Option second, all type of losses or damages can be claimed only if the contract is registered under the Registration Act. And option 3, only damages can be claimed which naturally arose from the breach unless notice of losses or damages not directly arising out of the breach which was known to the person guilty of the breach of contract. And option 4, normal damages which arise directly from the breach and special damage which are not in contemplation of the party when the contract was made, both can be claimed provided when there is a breach of contract, a public notice is given by the aggrieved party of the special loss suffered. In this question, the correct answer is option 3, that is, only those damages can be claimed which naturally arose from the breach unless notice of losses or damages not directly arising out of the breach known to be the person guilty of the breach of contract. This is the correct answer. Question number 62. Is it an absolute proposition of law that in a contractual relationship of a principal and an agent, a principal is always bound by the acts of the agent, and an agent takes no rights or incurs no personal liability under a contract entered into him as an agent of the principal with the third person? Options are no, an agent is personally and jointly and severally liable in all contracts. Option second, no, agent will be personally liable only when he does not disclose the name of his principal or when the name is disclosed but the principal cannot be sued for reasons provided in law. And option 3, no, an agent will be personally liable if the principal has expired in view of the Legal Representation Act. And option 4, none of the above. In this question, the correct answer is option second, that is, no, an agent will be personally liable only when he does not disclose the name of his principal or when the name is disclosed but the principal cannot be sued for reasons provided in law. Now let us see the question number 63. When will it be permissible to exclude the time spent of the pendency of an earlier suit for computing the period of limitation for filing a subsequent suit? Options are if the earlier suit is filed in a court lacking pecuniary jurisdiction, if the earlier suit is filed in a court lacking territorial jurisdiction, if the earlier suit filed in a court which lacks subject matter jurisdiction. Option 4, all of the above. Here the correct answer is option 4, all of the above. Question number 64. Is it correct that a fresh period of limitation commences from the payment made on account of debt after the expiry of period of limitation? Options are no, the fresh period of limitation will only commence if the payment is made before the expiry of period of limitation, but provided that the acknowledgement of payment only appears in the registered document. Option second, no, the fresh period of limitation will only commence if the payment is made before the expiry of period of limitation, provided acknowledgement of payment appears in handwriting of or in writing signed by the person making the payment. And option 3, if the payment after expiry of period limitation is on account of debt and accompanied by a court order condoning delay in making payment after the expiry of the period of limitation. Option 4, none of the above. In this question, the correct answer is option second, no, the fresh period of limitation will only commence if the payment is made before the expiry of period of limitation and provided acknowledgement of payment appears in handwriting of or in writing signed by the person making the payment. This is the correct answer. Now let us see the question number 65. The period of limitation to set aside a sale of execution of a decree under Article 127 of Schedule of the Limitation Act 1963 from the date of the sale is option A, 30 days, 90 days, 60 days or 10 days. In this question, the correct answer is option number 3, that is 60 days. Question number 66. When a new party to a suit is added, then can the suit qua the party be taken to be instituted from the original date of filing of the suit? Option R, no, the suit is taken as filed by or against a party only when the order impleadment is made. No, the suit is taken as filed by or against party only after the date of filing of the application or for impleadment. Yes, it is correct provided that the court is satisfied that the omission to implead the person was due to a mistake in good faith. Yes, provided that when the suit was originally filed, it was filed on behalf of a minor and who after becoming a major pendent light ratifies the filing of the suit from the original date. In question number 66, the correct answer is option third, which says that yes, it is correct provided that the court is satisfied that the omission to implead the person was due to a mistake of good faith. Question number 67. On 1/1/2010, an amount is deposited by the plaintiff with the defendant not being a loan. On 1/1/2012, demand is made by the plaintiff for repayment of the deposit. On 1/1/2014, suit for recovery is filed for the amount of deposit. Is suit within the limitation? Options are: the suit filed on 1/1/2014 is time barred as it is filed 3 years after having made the deposit on 2010. The suit filed on 2014 is within limitation because limitation of 3 years commences on 2012. Option third, neither one nor two. And option 4, the suit is not time barred only in case where the deposit is made with a bank and not a private person. In question number 67, the correct answer is option second, because the suit filed on the 1st January 2014 is within the limitation because limitation of 3 years commences from 2012. So this is the right answer. From because 2012 the repayment is demanded. Question number 68. Consider the following statements. Statement first, the arbitral tribunal cannot rule out of its own jurisdiction. Statement second, oral arbitration agreement is enforceable. Statement third, the parties may choose mid-arb as a procedure for settlement as of their dispute. And statement 4, there must be pre-existing written agreement arbitration for dispute settlement by arbitration. Which of the statement is correct? In question number 68, the correct statement is correct statements are third and fourth statement. They are the correct statement. Third statement is related. The parties may choose mid-arb as a procedure for settlement of the dispute. Statement 4, there must be a pre-existing written agreement of arbitration for dispute settlement by arbitration. Question number 69. Is the statement of law correct that an arbitration cannot decide ex equo et bono? Take the most appropriate answer. Options are: yes, it is always correct. Option second, no, it is not correct. Option 3, yes, it is correct provided only if the parties have expressly authorized the arbitrator to do so. Yes, provided the parties expressly or impliedly authorize the arbitrator to do so. Here the correct answer is option third. Yes, it is correct provided only if the parties have expressly authorized the arbitrator to do so. Ex equo et bono means matter to be decided according to the principle of equity rather than by points of law. This Latin maxim more focusing on the equity rather than on law. Now let us see the question number 70. Whether an arbitrator under the Arbitrator and Consolation Act has the power to correct and interpret the award after it has been pronounced. Option first, no, as the arbitrator becomes functus officio. No, the arbitrator does not have the power of review. No, as section 34 of the Arbitration and Conciliation Act prescribes procedure for setting aside the award. And option 4, yes, in terms of section 33 of the Arbitration and Conciliation Act. In question number 70, correct answer is option 4, because section 33 talks about the correction and interpretation of the award of Arbitration Act. Now let us see the question number 71. In execution of a money decree of rupees 1 lakh, the detention of the judgment debtor in civil prison for 3 months may be ordered. A, as one of the modes of the enforcement subject for certain restrictions and conditions. B, if he willfully does not comply with the direction disclosed by affidavit the particulars of his assets. Consider the following statements and choose the correct options. Option first, both A and B are correct, and option second, neither A or B is correct. In this case, both the options are correct. Both A and B are correct. Question number 72. In a suit for partition of property and for separate possession of a share therein, the civil court having declared the rights of several parties interested in the property. Option A, which is assessed to the payment of revenue to the government, must take over the matter for such partition or separation to be made by the collector. Option second, which is not so assessed to payment of revenue to the government, must examine if the partition or separation can be conveniently made, and for this may issue a commission to make the partition or separation. Option 3, if on examination of the report of the commissioner the court finds that the property cannot be divided by metes and bounds, it may put it to sale and divide the proceeds thereof. In the above, which of the following options are the correct options? A, B and C are correct. In the given statements, options, the first option is correct, which says that A, B, C and are correct. All of these statements which are provided in question number 72 are correct. Question number 73. When and how a decree can be passed on a compromise in a suit against a minor sued through his guardian? Options are: requires the affidavit of the guardian and the compromise is for the benefit of the minor. Option second, suit against a minor cannot be compromised except with the permission of the guardianship court. And option 3, both parents of the minor must furnish an affidavit stating that they have compromised. And option 4, if the minor signs the compromise deed. In the given options, option first is the correct answer, requires the affidavit of the guardian and the compromise is for the benefit of the minor. Question number 74. In a suit for recovery of possession of a residential premises from the lessee after the determination of the period of lease, on being satisfied that the defendant, with intent to delay the execution of the decree that may be passed against him, is about to abscond from his local jurisdiction limits, the court may call upon the tenant to furnish security for his appearance until satisfaction of the decree. Options are: the above statement is not correct, absolutely correct, partly correct, as order of his nature can be passed only after the judgment is pronounced, partly correct, as such as an order can be passed only where there are areas of electricity bill. In question number 74, the correct answer is option second, absolutely correct. This statement is absolutely correct statement. Now let us the question number 75. An executing court cannot determine the questions relating to which of the following: discharge of decree, satisfaction of decree, modification of decree, or execution of decree. The execution court cannot determine the questions relating to modification of decree. So option third is the right answer.